This is Elizabeth Townsend. It's November 9th, 2001. This is an interview with George Rountree for Dean Massaro's Preparing for Lives in the Law Project. All right, before we begin with the question I just asked you, since we put on the tape, we'll ask the first question we've asked everybody, and then we'll go back to sort of the important topics. Does that sound okay? Sorry.
Elizabeth, we'll do it any way you want to do it.
Okay, sorry, it's so messy. Why did you go to law school, and what was it what you expected when you got there?
Well, the reason I went to law school is because my direct ancestors had been practicing law in Wilmington, North Carolina since 1842. So my grandfather began practicing law. My great-grandfather began practicing law in 1842 in Wilmington, having graduated from University of North Carolina at age 18, where he matriculated at 14. He got his law degree at 18. He was fairly bright. His oldest child, Meta Davis, was married my grandfather, George Rountree. They had, their last child was George Rountree Jr., my father. And my father obviously practiced law with his father, and his father practiced law with his father-in-law, so it was not unnatural that I had an interest in the practice of law. And my family had represented railroad interests for a long time in North Carolina. And of course I didn't know anything about railroad interests. I didn't know much about North Carolina when I went to law school at the University of Arizona, because my parents had divorced and I moved to Phoenix with my mother and sister. My mother's mother, my grandmother Johnson, lived in Phoenix. And went to high school at North Phoenix for a couple of years, then West Phoenix, and graduated and matriculated at the University of Arizona as an undergraduate, won a football scholarship, and ended up just playing basketball, and had a Baird scholarship and some other financial help. So I was able to make more. At the end of this last year, I had more money in my pocket than I started, and my mother gave me $50 the first day I went to school, and that's the only money she ever gave me my entire collegiate career, including law school. So I took it as an opportunity to do what I knew I wanted to do. Actually, when I was in high school, I thought I wanted to do one of two things. Either want to be a basketball coach or a lawyer. But when I got to the University of Arizona and inquired of my basketball coach, Fred Inc., what he made, he told me $10,000 a year. I said, I'm going to do something different. And he'd been at it 33 or 34 years at that point, and had won over 500 games, so he'd been very successful. He's taken the team to NCAA, NIT, won the Border Conference Championship a number of times, was a very fine person. And after I graduated, I got an ROTC commission. Went to Fort Knox, Kentucky. Spent 21 months and 18 days in active military duty. And if you've ever been on active military duty, you understand why you know exactly how many days you spend, particularly if that's not your life's choice. So I returned to Arizona in late August of 1957, entered College of Law, took the law school admission test. Not that it had anything to do with one's admission, because if one had graduated from a four-year institution in the state of Arizona and applied for admission to law school, one had to be admitted. So the test was just to get the Princeton folks who managed the whole process some idea of a norm, what a law school should expect from a matriculating freshman. And at that time, John Lyons was the dean of the law school. And Chester Smith was my favorite professor. And I remember, even now, things that Chester Smith taught me that I find young lawyers whom I hire have no idea about. Constructive trust, purchase money constructive trust, the possessive factor in determining entitlement to personal property. You know, the old Armory versus Del Marie. Okay, the first case in the personal property case book. Possessor has title of the property against the whole world except the lawful owner. That's my recollection of the case. In any event, one of the most remarkable things about Chester Smith was that he said the first day of the class, you may go buy the case book if you'd like. It's $27 or whatever it was, in whatever course. And he taught trusts and personal property and real property and one or two other courses, mining law, water law. He said, you may do that if you want to, and I commend that to you. But the exam questions will come entirely from my lecture. And if you come to class and take careful notes, you will do well. In fact, I will tell you what the questions on the final examination are going to be. And I will give you the answers. And the reason I'm going to do that is because I know what is important for you to know to be a lawyer. You don't. This case book doesn't. But I do. And I'm going to tell you what that is. And if you don't pick it up, it's your fault. And of course, I didn't believe that. I mean, I never had an instructor say that to me in my entire career. Grammar school, whatever. But when the first semester class was over and I realized that, in point of fact, he had given us the questions sometime during the semester. I mean, he'd say, now you might see this question on an examination. He'd give the question exactly. Now, what is the answer? And the answer is X, but you've got to acknowledge that Y must be discussed. And Z is potential. So you need to tell me about X, Y, and Z in order to get an A on that exam question. I realized that he had done exactly what he said he was going to do. I'd never had a professor do exactly what he or she said he or she was going to do. I was shocked. So the next time I took his course, I got an A. My mother was Phi Beta Kappa, my father was Law Review, and I was supposed to be fairly bright, and I realized that I wasn't going to be fooled twice. So Chester Smith was definitely my favorite law professor. And in fact, I have taught a number of classes at the University of North Carolina at Wilmington in political science and history, other things. I was fortunate enough to be elected to the State General Assembly in North Carolina in a long time ago, 1970 and 1972. So, when I was asked to teach the course in current political environment, something of that nature at UNC Wilmington. And I told the students what the exam question was going to be. And I gave them the full answers. And amazingly, I had a couple people flunk the course. And I told them at the outset of the course, I said, now, you have never had a professor do what I'm going to do. I'm going to tell you during the course of the semester exactly what questions you might expect on the final examination, and I will give you the perfect answer. And many of you are not going to believe me. And you're going to come to the final examination, and you're going to be amazed that here's a professor who did exactly what he said he was going to do. And sure enough, that happened. Of course, I raised havoc with the grading system at the University of North Carolina Wilmington because they had 24 people in the class and 18 of them made A's. Okay? That's fine. I know what's important for you to know. I'm teaching this class. I've been in politics. I know what's going on. And I know what I think you ought to know in order to be an effective voter, understanding what happens when one sends a legislator to the Capitol. So I got a call from the provost who wanted to know why 18 out of 24 had made A's. I said, well, 3 flunked. So how do you count that? I said, well, they're smart. They gave the right answer to the question. Well, how'd they do that? I said, I gave them to them. Well, why'd you do that? I said, because I know what they ought to know. They don't know. So this is not a game. My job is to teach them. It's not, well, read this book and ferret out of it what you think I'm going to ask you. You might as well go to Las Vegas. So, because my experience with Chester Smith had taught me that a person who feels that the instructor has a duty to teach, that is, to expose the student to that which is significant in order to give the student the base from which to emerge in life and operate effectively, then the Chester Smith way to do it is the way to do it. I mean, I had a lot of other professors who, in college, in high school, and whatever, I had an English teacher in high school who said, George, you've got to do this term paper, senior English. You know, it's most of the grade, my senior year, second semester. I said, well, Miss Slavens, I'm not going to have time to do that. You told me at the start of the year that nobody's going to make an A class. You just didn't give A's. And, you know, we've got the state basketball tournament next week, and I got to play in that. Then I'm on the track team, and I'm going to be tied up in that till the second week in May. And I'm just not going to have time to do it. And she looked at me and said, well, George, I'm just going to have to give you a B. Now, here was a woman who defied anyone making an A. So why the heck was I going to try? And on the other hand, you have the Chester Smith, who wanted everybody to make an A. It's like the basketball coach. He wants you to win every game.
So what about the curve system? I mean, I like what you're saying, but the curve system seems to do the complete opposite. Everyone works as hard as they possibly can, but only a certain amount can get A's. Do you think that shouldn't be the case? I mean, there's just this whole pressure, particularly first year, of only a small percentage is going to get A's. And Chester Smith, I mean, that's the way it should be. It should be about everybody learning and knowing the material at the end and feeling good about themselves and that they can be confident about going out and using the material. But I mean, U of A isn't any different than anywhere else. There's just this intense pressure for curve and making people into C students and B students.
Do I think that is the way to stimulate a budding legal mind? No, I don't. I mean, a particular class of students may have extraordinarily bright people. And for an A mentality to be accorded a B takes a lot out of the A mentality, at least with that teacher. Mm-hmm. And that's the sort of thing that gives the University of Arizona and any public institution a bad taste. I mean, I'm trying to raise money from time to time for the law school. I'm not in the Jim Rogers League, but I do what I can. And one of the common things I hear is that I didn't get anything out of law school. It was just a big challenge. It was like going to the zoo. And did I like the animal trainer or didn't? That thought process clearly exists among a great number of people, particularly in my generation and the one immediately following my generation. I mean, I'm 68. I've slowed down some. I get to my office about 6:30 in the morning. I leave about 7 o'clock at night. I don't work Sunday afternoon. Okay, spend that time with my family. But I'm billing about 60 hours a week because I'm working more than 60 hours a week. And practice has been very good to me. I have a good client base, people that think I know what I'm talking about. But it's not because I'm bright. It's not because I have the greatest mental acuity. I work harder than most. So if I'm in a big lawsuit and I know who my opponent is, of course. I want him to see my car at my office when he drives to work, okay? So, if I know he's driving to work at 7 o'clock, I'm going to be there at 6:45. If I know he's driving to work at 6 o'clock, I'm going to be there at 5:45. He's going to see my light on in my car there before he has started. Because I want him to know he may be smarter than I am, but he's not going to outwork me. And it's not a matter of being the smartest in the world. It's a matter of who has mastered the facts, who has a level of credibility with the court and the system. That person, more often than not, gets the best result for the client. That's not always a victory. One does not always know whether one has won. One W-O-N-E, O-N-E versus W-O-N. Because in practice law, it's not like playing 40 minutes and the gun goes off and there's a winner. There's an appellate process, and you may get a judgment against someone who's impecunious, can't pay it, and what have you won? So, getting the best out of the hand you've been dealt is your job. Your job is not to pull the wool over anybody's eyes. In fact, lawyers who try to pull the wool over judges' eyes become very well known. And those lawyers are not accorded the kind of credibility and deference which the bench can accord and can make the lawyer and the client feel at ease and comfortable. I mean, it is a stressful environment. So it is, hard work is absolutely indispensable. Honesty is the second leg of that stool. And the third leg is trust. Does the judge trust you? Does your client trust you? Okay. And if any one of those legs is missing, that chair is going to fall apart. It's got 3 legs that are holding it up, like that. And you take one of them away, and it's going to fall down. So if you're going to be successful practicing law, you've got to be willing to do all 3 things.
Okay, can we talk a little bit more about each of them?
Sure.
Let's start with hard work. When you talk about hard work, what do you mean by hard work? I mean, I think I know what you mean, but...
I mean focused attention to the issue and the facts. What issues do you get out of the facts? Effort without focus is fruitless. I mean, I had a football coach one time that said, don't ever make the mistake of confusing effort with results. Winston Churchill said, I was delighted when I passed from the tossing sea of cause and theory onto the firm ground of result and fact. And it's result and fact in which I'm interested, and in which my client's interested. I mean, I charge the highest hourly rate in my part of North Carolina. And I got more to do than I can say grace over. And it's not because I was Phi Beta Kappa, which I wasn't, or I was Law Review, which I wasn't. I think I work harder. I try to understand what these facts presented to me. From those facts, what issues emerge. And in order to determine that, one must determine what the client wants. What is the client's goal? You know, when you're playing basketball, there's a goal each end of the floor. And the goals are about 88 feet apart. The floor is 94 feet long, and the goals are 3 feet from each end from the end line. So in playing basketball, I always knew what the goal was. In football, there's a goal line. In hockey, there's a goal. And there's a goalie. So the term goal is one that should be very familiar with all aspiring lawyers. And assuming an engagement for a client without understanding what the client's goal is or goals are is a grave mistake. Because you never know then whether you perform satisfactorily. And you'll have a client come in and say, well, I want to recover $10 million from this person. I've been wronged. My car was wrecked. My wife was killed. I've been seriously injured as a result of the operation of opposing vehicle by a drunk driver. Well, how much insurance does the guy have in the car? How much property does the driver of the car have other than insurance to cover a judgment? And it would be unusual to have a $10 million cover, absent some public company which has a significant, not only retention, but also significant cover from an insurer. So, getting the goal, making sure the goal's realistic, and then enticing the client to tell you what the facts are. All of them are absolutely essential. Once you've done that, then you can focus with the effort in the arena which can produce the best practicable result for the client.
Okay, I have two questions before we move on. Is it always easy to know what the client's goal is, or do you find that there's sometimes that's hard to figure out? I mean, or do you think that the client always knows what their goal is, or do you sometimes have to help them out to figure out what the goal should be?
Well, there are two questions. Is it easy to determine what the client's goal is? And number two, does the client know what the goal is? And let me take the second one first. Frequently, the client does not know what the goal ought to be, but speaks in generalities. I want to punish that person. I've been wronged. And an education of the client about the remedies afforded by the law and equity, and under any administrative regulations which are pertinent to any administrative inquiry through which you're passing. Those are obviously very important. But I never take an engagement without determining what the client's goals are. It may take 2 or 3 conferences. It may take bringing a spouse in or some other adult or an advisor. If the client has an uncle who's a lawyer or a brother-in-law who's a lawyer, then you need to be careful about talking to this putative client without getting the support of this other thing out there who may or may not know everything you've been told or you're going to be told. So it is not always easy to determine it, but if they throw it at me in English, I'll pick it up. Okay? And I'll ask them questions until I'm confident that they, the clients, understand what I think is reasonable based on 42 years of practice law, or 41, and what is cost effective in that scheme of things. I mean, I'm in a business. I enjoy practicing law, otherwise I wouldn't be doing it. Certainly this long. And I'm just glad I've got hair. It's gray, but I'm glad I've got hair. But you cannot allow an excellent result and no reasonable fee to occur. If I'm going to do some pro bono work, and I do, I want to make sure that it is intentional at the outset. And there are a number of widows or battered women or orphans or people that need help can't afford it, whom I help. Why? Because they need it. And the money's, I got plenty. Probably got more than plenty. And my kids think I got more than plenty. But then I don't want some corporate entity to get into me for $100,000 or $200,000 and then walk away from me. See, I don't ever sue a client for a fee. I mean, you can't win. So I've become a great deal more sensitive as the years have passed to make sure that collections are consistent with the effort and the results.
All right, can we talk a little bit more about that, and we'll go back. We have many steps back, but we keep having so many interesting things. We've heard from a lot of people who feel like, especially younger lawyers, who don't get their clients to pay, and they have a lot of trouble collecting. And I thought maybe since you talked about it, maybe some more strategies to make sure, sort of ideas on all that.
Sure. Setting a fee and collecting the fee are critically important to the practice of law. You've got to make a decent living. You're expected to make a decent living. You're expected to be donative in the community. You expect to give United Way, to your school, to your church, to a number of charities. You're expected to wear decent clothes. I mean, I wouldn't come in here in a t-shirt, okay? I mean, that would not project the kind of image which I think the University of Arizona expects me to project wherever I am. I mean, I'll be in New York next week. I'll be in a gray pinstripe suit with black shoes and black socks and French cuff and all that, because that's that environment. But most lawyers, and don't have to be young, most lawyers hesitate to talk money with the client. And then if you hesitate to talk money with the client, you ought not to expect the client to pay you very quickly. Before the engagement is cemented, a lawyer must discuss the fee with the client. Okay? So before the end of the first conference, you've got to say what the fee is going to be or how it's going to be computed. And there's several things that I do. Number one, I discuss the fee. It's either going to be a flat fee or an hourly rate or a contingency. And I might say, well, I'll take this case for $75,000 or $100 or $20. Or I may say, well, what I want is a $15,000 deposit on fees, and my rate is $300 an hour or $350 or whatever it might be in that particular situation. And I will bill against that deposit until that deposit is consumed, after which I will send you a bill and expect you to pay it within 15 days. And if you don't pay it, I'm out of here. I'm out of here. Because, as I tell the client, the foundation of the relationship is trust and confidence. If you don't have trust and confidence in me, I don't need to be around. If I don't have trust and confidence in you, you don't need to be around. Now, you don't want to mislead me. I don't want to mislead you. So it's a reciprocal thing. If I'm going to help you, you have got to believe in me. And if I'm going to put forth the effort to help you out of this dilemma, I've got to believe that you're going to pay me.
Can you do that? Can you just drop a client if they don't pay, or is there situations where you can't?
Well, there are situations where you can't.
Or is it like a threat? So
well,
pay?
No. Federal court, you can't just walk away. I mean, any court you've got to have permission to withdraw, but in state court in North Carolina, if you haven't been paid and you've been practicing law as long as I have, judge is going to let me out and give the client an adequate time to locate additional counsel and who can get up to speed. Federal court, you get on a schedule, and that case is on that schedule. So particularly in federal court, and I don't do any criminal work in my work in federal court is mostly admiralty and cases that evolve from transactional disputes. Client wanted to buy a corporation, alleges breach of contract, some of the warranties, or negative covenants, whatever they may be, and then sues, primarily in federal court because of the diversity of citizenship issue. And so you've got to get a hefty deposit in federal court, and you've got to do some research in advance of taking the engagement to determine that the client is sufficiently sensitive to your importance that he's going to pay you.
How do you do that?
Well, you find out from him what other lawyers he's used, what other states, what other jurisdictions. Who's your general counsel? I'd like to talk to him. That's what you do. But it's my experience that the commercial client respects the lawyer who talks money to him right up front. I mean, that's what it's all about. You're trying to make money for him or save him money. And that's going to cost him. Is he willing to pay the transactional cost attending that situation? Yes or no? Well, how much is the transactional cost? Well, I'll give you a fixed fee if you want, or I'll give you, I'll take the case on a contingency basis, or I'll have a blended fee. You pay me $150 an hour and 20% of the recovery, rather than $300 an hour, $350 an hour, and no percent of the recovery. So you have to be a little bit innovative. I mean, Einstein once defined insanity as the continuation of the same process is expecting a different result. I mean, you can't. That is insane. Do the same thing time after time, expect a different result. You wash your face with soap and water and expect your feet to be clean. It doesn't make sense. So the empirical process has taught me a lot of things about how to collect money, but I've never been afraid of talking money with the client. And a way to determine whether you want the case or not, whether the client believes in you, is going to be the kind of client you want to have, is say, before I get started, I want a $5,000 deposit, or 10, or 50, or whatever, depending upon the kind of case it is. And that's hard for a young person to do, because a young person says, I may run this putative client away. Well, let me tell you something. You're going to be so much better off running him away or her away at the start than worrying about collecting. You've done all this work. You're angry. You're irritated. It prevents you from moving forward positively with the engagements that you have that are good. So I've found it to be a very salutary cleansing methodology. Get a big deposit. And some of these corporations that call me, oh, we don't give deposits. Okay, fine. Go someplace else. What about a $10,000 deposit against fees that I said that did you not understand? Was I not clear? The only way I know to give it to you is in English. Now, if you don't want to do that, I understand. I don't want to be a problem for you. Don't want to be a burden, and you should find somebody else. Now, you can do that when you have sufficient business. It's hard, particularly for a young lawyer, to do that. But that's where the young lawyer wants to be after about 8 or 10 years.
What do you do in the early stages then?
Well, there are a number of things you can do. First place, you will do some things, say for a $1,500 deposit, realizing you may not get paid what it's worth, but you're going to be learning. It's the first time you've done that. Or you may do some things that afford a legal challenge that you might not otherwise have an opportunity to do, realizing that you might not get paid, but you want the experience. So it's an art, it's not science.
Let's go back to the next one. Enticing facts out of clients. All the facts. You said that as one of. Could you talk more about what you mean by that?
Sure. Number one, make sure you have a lengthy conference with the client by herself or by himself. Client will bring in a spouse, child, uncle, father, advisor. You're not going to get it. You're not going to get the pure version. You're going to get an adulterated version because these other people, they're in that mix, and your client doesn't want to tell everything. So make sure you have a lengthy conference with the client by him or herself. Number two, there are certain facts asserted by a client which ought to be the subject of proof, objective, demonstrative proof. Photograph, letter, deed, agreement, receipt. Well, where's the written document? Well, I don't have it. No, wait a minute. You've said that you paid this bill. Did you get a receipt? Yes, I did. Well, the plaintiff's suing you to recover that. Why is he or it suing you if you have this receipt? Well, I don't know where it is. Well, now wait a minute. If you had a receipt and you now don't have it, you can't locate it, what proof do you have that you paid it? Do you have a check? Canceled check? No, I paid it by cash. Well, you paid $8,000 for this used car by cash. I got a receipt and can't find it. Now, tell me what jury and what county is going to believe that, okay? You just gave this guy $8,000? You do that every day? And you don't have any written evidence that you paid it? That's not going to fly. You don't need me as a lawyer. You don't need somebody to practice law. You need somebody to practice magic. And I'm not the magician. That's kind of a basic thing. But where factual evidence is susceptible to objective proof, get it. Another example. Someone says that he or she had his or her boat berthed at a particular dock, and the electrical system failed. Go to the dock, take a picture of the dock, the electrical post, where that post is in relation to where the boat was actually berthed. How long is the cord from the nexus at the boat to the electrical system on the dock? Take photographs, measure it. Where a fact is capable, susceptible of objective proof, get it. The client doesn't remember everything. So it's always important to have more than just the first conference with the client, because your questions are going to refresh recollections. And the client's going to go home and ask the boyfriend and the girlfriend about it, and they're going to talk about it, and that discourse is going to produce some new thought. Never rely solely on your client's recitation of the facts. You're going to get killed if you do. That's why obtaining the objective evidence is so critical in a lawsuit.
You had talked about the uncle that's a lawyer, or and getting them on board, or how do you do that?
Well, first place, in the private session with the client, I find out exactly what the relationship is, and exactly what the client expects my relationship vis-a-vis the uncles to be in connection with a result for the dilemma for which I'm engaged. I mean, what is he supposed to do? What am I supposed to do? There can be only one captain on this ship. If he's going to be the captain, then you need somebody else because I'm too expensive to be a mate. If I'm the captain, I want him to understand that. You're going to hold me responsible for what happens on this ship. I got to be the captain. And if that's a burden for you, or too much of an obligation, or you don't like it, I understand. Go find somebody else. It's okay. Recognizing the difficult client early on is critical. And that, there again, it's an art. And I have a couple of difficult clients right now who are taking advice from other folks, and so I've got meetings set up with them on Monday when I get back to Wilmington because either I'm in the mix or I'm not.
So
You know, it's like when you're in school. You expect your boyfriend to listen to you. You didn't expect him to go to the Theta House and listen to some other woman, did you? Okay, same deal. Except a little different result, a little different predicate.
So, what other kinds of difficult clients are there? And how do you handle them?
Well, I suppose one of the most difficult kinds of things that a young lawyer can face is a quasi-domestic problem. Husband and wife come in to you and say, we want reciprocal wills, each leaving everything to the other. Don't have any children, to the survivor. If there's no survivor, then to my mother and father, or to my sisters, siblings, whatever. A year later, you do that, okay? Not a difficult thing to do. A leaves to B, B leaves to A. A makes B the executrix, B makes A the executor. A year later, the husband comes in and says, George, I got a girlfriend and I don't want to leave everything to my wife, okay? I got this insurance policy over here for the girlfriend, and I want to leave her a car, and I want to leave this house that I just bought over in Coronado, California. And the lawyer needs to say, I'm not doing that. And the husband's, God dang it, you're my lawyer, you've been my lawyer for years, you're going to do it. I represent both. Well, I'll do it, but I'm going to tell your wife, okay? Because she's my client just like you are. And you lose a client. But you don't want that guy as a client anyway. My mother told me early on, always associate with honorable, successful people. They pay you and they don't ask you to do anything illegal or improper. If you don't do that, son, you're going to be in trouble. If you do it, you're going to be successful beyond your wildest dreams. I've tried always to do that. When I haven't, it's been a problem. So I violate that rule very infrequently. Always associate with honorable, successful people. And let me tell you another situation. Young lawyer, been in a big law firm for a year, wants to advance in that law firm. One of the senior partners comes to him and says, "Oh, now you got to tell a lie, okay? You got to go tell your adversary who's asked you this question, you got to tell him a lie." That's a tough position. Mm-hmm. But as a young lawyer, you got to say, that's going to be told, you got to tell it. If that costs you my job, then I don't want to work here anyway. That's hard. But life is hard. My mother always told me life is not fair. The word fair is nowhere to be found in the Bible. I've looked for it. Now I'm not a holy roller, but I'm Episcopalian, been Episcopalian all my life, and read the Bible on occasion, quote it to jurors from time to time, because between the Bible and Shakespeare, the two greatest works in the English language that have ever been. let not your heart be troubled, neither let it be afraid. When you're talking to a jury about your client's position as the parent looking after the child, and the child expecting mama or daddy to take care of them, let not your heart be troubled. So, if you don't adopt that rule, you're going to be in trouble.
That's the second prong, honesty, of your 3 prongs: hard work, honesty, and trust. What about trust? And what happens when a client doesn't tell you all the facts and you learn things later, or other situations where people break your trust?
Well, there are 2 prongs to the second question. What do you do when you find out your client hadn't told you the truth?
Right.
If you learn the client has lied to you, get out. Get out. If the client just has misinterpreted the facts or doesn't understand them, then you must call the client in, probably with another advisor, the client's brother, father, mother, accountant, engineer, whoever, so that the client can and the advisor can hear you say, now, at the outset you told me X was the fact. In point of fact, X is not the fact, it's Y. And because the fact is Y, your expectation to get A out of this lawsuit is unrealistic, not going to happen. I want to tell you that. And I want you to think about it, and I want you to come back to me tomorrow or later this afternoon and tell me whether you want me still to represent you. And you may want to go find somebody who says that he can get result A whether the facts are X, Y, or Z. And usually the client will come forward and understand, and you can go forward and continue to represent the client without a problem. But the trust thing, the 2 facets of that. One is the client's trust of the lawyer, and the lawyer's trust of the client. We've gone into it a little bit, but if the client does not trust you, you can't do the job.
Can you give me an example? Have you ever had of a situation where that's happened?
Oh, sure. Client hires you to file a lawsuit against a vessel for not paying a bill for fuel. And you file a case, and you tell the client that the client got back some of the fuel, so the client's not going to be able to get the full fuel bill at inception, but the full fuel bill less a credit for that fuel. The extra bunkers that were on the vessel the client got back. And the client said, no, I want the whole thing. So-and-so tells me I'm entitled to the whole thing. Well, no, wait a minute. You don't trust me? You need to go someplace else. You don't think I know the law? Okay. I may not. I mean, I believe I do. But you need to go someplace else. That's the sort of situation. The trust with the court is equally important to the trust that must exist between counsel and client. In 1965, I'd been engaged by an insurance company, marine insurance company in New York, to represent it when it was sued by a big contractor in central North Carolina as a result of the sinking of a dredge. And what happened is that a big wind came up and blew all the water out of this creek. And the dredge got caught. Here's a dock, okay? Mm-hmm. All the water goes out of the creek, and the dredge comes down here, okay? And then the gunnel, that is the side of the boat, gets caught under the dock. The water comes up, and the boat can't go anywhere. So the boat sinks, okay? In that case, it was a warranty in the policy of insurance, which required the ship owner to have a watchman at the dock at all times, just to prevent that sort of thing from occurring. The lawsuit was over about $140,000 or $50,000. This is 1965. That's a lot of money. And the insurance company sent a big-time New York lawyer down to see how I was doing. And in the pretrial conference, you're aware of what a pretrial conference is, I had stipulated that the only issue was a breach of the watchman warranty of the policy of insurance. If there were a breach, then our position, we didn't know anything. If there were not a breach, then we owed the money. And the lawyer from New York was just horribly excited about all that, and he argued to the judge that all kinds of other defenses specified in the answer and covered by responses to interrogatories, or Rule 36 request for admission, or whatever. And the judge looked down and he said, "Mr. Rountree, did you tell opposing counsel that the only issue in this case from defense standpoint was breach of the watchman warranty of the insurance contract?" I said, "Yes, sir." He said, "Well, that's the way it is." I got fired. I never had another case from that client, okay? But I'll tell you, everything I told that judge from that day till he died, he believed. He believed. And that was a hard thing for me to do. Because I knew this New York lawyer was going to go back to New York and tell this big insurance company, which had given my firm a lot of business over the years, that you don't want Rountree because he sold you down the pike. Now, I could have said, "No, Judge, I didn't say that." And the judge would have said, "Okay, well, we're going to have these other issues in this case." But he would never believe me again, okay? It was critical to me that the court believe that what I say is true. No baloney about it. If I don't know, I say, "Judge, I don't know." The judge said, "What kind of car do you have?" I don't say it's red. I say it's a Lincoln. Answer the question directly, just like you would a law school question. You got this lengthy recitation. Who prevails and why? Okay? We need to say the plaintiff, and here's why. Or the defendant, and here's why. You don't say, "Well, the day before yesterday I saw a similar situation," and go on with a litany that transcends the miracle of the transfiguration, and not get to the answer. So what I'm trying to do to establish trust in the judiciary, and it gets around, answer the question immediately. And most questions are yes or no answer questions from a judge. And number two, always be candid with the court. And never say, "Well, Judge, to be candid with you." I mean, what's the judge going to think? Everything else I've said is not candid? Or, "Judge, to tell you the truth." What does that mean? I have never told you the truth before then? I mean, does that make sense? To say something like that? Don't say things like that.
So it seems like what you're saying throughout all of this is that you have to stand your ground and be true to yourself and be honest and strong. And that it isn't about where you get these sort of weird situations where people believe you are supposed to do everything you can for your client, and that it's your integrity and your honesty and your trust that is and that the client can come to you and leave, but you have to be it's your center, it's your rock. Is that this isn't like do everything for your client kind of thing? Why do you think that you hear that so much, of that sort of...
There's a huge premium put on winning. I watched Arizona play basketball last night. Arizona won. I was delighted. Maryland folks were in a state of depression. But the practice of law cannot be all about winning. It's all about doing the best you can with the facts applied appropriately to the law, or the law applied appropriately to the facts, to get the best result you can for your client, without misleading anyone, without lying to anyone, without distorting the process. I mean, that's one of your obligations to the court, the system. It's more important than anybody. And if you don't feel that way about it, you need to do something else. You need to take your law degree and go be in-house counsel for somebody.
Okay, I've got two, I don't know if they're silly questions, but do you ever give a client a second chance? Or is your rules pretty hard and fast?
Well, I mean, no rule is so hard that it would be draconian. It depends upon the circumstance. If I feel that the client has lied to me, then I don't trust him anymore. Then I can't help him and I shouldn't represent him. Now, are there circumstances where I felt the client has lied and I've continued representation? Yeah. Where the client has acknowledged that he lied, okay? Explained to me why he did that to me. And convinced me that he wanted me to continue to represent him because he trusted me and agreed never to do that again. Then I've continued to represent the client.
Okay. What about your relationships with, I'm thinking about, well, okay, I'll just ask the questions, kind of relationships with non-clients, family, friends, children, that do you have the same sort of, I mean, is being a lawyer and having that value system the same that you deal with other people? I mean, is it the same sort of belief system? Sort of, it's kind of that thing of sort of how you act at work and how you operate with people. Is it the same way in terms of honesty, integrity, you know, no lying, those sorts of things? Like if a friend
Sure.
comes to you and, I mean, how you lead your life is how you lead your, I mean, I guess that's the question, you know what I mean? Like,
Mm-hmm.
should you be the same person as a lawyer as you are as a, you know?
Should be, shouldn't you?
I think so.
I mean, the dichotomy,
Mm-hmm.
the problems of the dichotomy
Mm-hmm.
would infect each side of your life.
What about like with kids? How do you instill that kind of stuff with kids? I mean, do you have those sort of rules when kids are growing up so that they understand that? I mean, how do you keep a society going with these sorts of your belief system?
Well, my wife and I have 6 children. We got 8 grandchildren, another grandchild on the way, and my wife has been the matriarch of the family because I've been gone a lot. I mean, I'm not always there. And each of the children growing up has understood that what Mama and Daddy said was what the law was. It didn't make a difference what their peers were going to do. I mean, we didn't want them to have anything to drink before they were 18. We didn't want them out after midnight before they went to college. I mean, nothing good ever happens after midnight. My mother always told me that you can do a whole lot. You can do the same thing before midnight you can do afterwards. You can do it a whole lot better. She knew what she was talking about. And I remember one night, about 11:30, one of our daughters came in. She was 18. She was coming home from college, and she said, "I'm home." My wife jumped out of bed and accosted her and said, "You've had something to drink. You've had something to drink." Why? You were driving and had something to drink. Now, number one, my wife never went to sleep until all the children were home, okay? Number two, my wife has the capacity to discern a lot. I mean, the things that mothers can do that we men just marvel at. But I mean, the children understood that when the queen bee said something, she meant it, and if there any question about it, the king had come along and make sure that there was no misunderstanding, that the English language had not been distorted, and that one's auditory powers had not been impaired. Otherwise, we're going to find some way to restore them. My wife and I believe very strongly that discipline is one of the important ingredients of success. I have my pad that I carry around with me. Lawyers have pads all the time. Every time I put a new pad on the face page, which I never take out, the ingredients of success. The 5 or 6 things you got to do to be successful. And I write them out every time I change pads. And that top page never gets torn out. Everything else is torn out underneath. Always associate with honorable, successful people. You're going to succeed by discipline and devotion. You're only going to be successful to the extent the people around you want you to be. We have a lot of secretaries and paralegals and younger lawyers in my office. If they don't want me to be successful, all they got to do is fail to do something. Well, gee, Mr. Rountree, I forgot. I can't do everything, Mr. Rountree. If they don't want me to succeed, I am not going to succeed, because you can't do it by yourself. It's a team effort. There is no I in the word team. And in my law practice, we have 6 lawyers, and we operate as a team. We may be working on 4 or 5 big cases at a time, and there are at least 2 of us, of the 6, working on each of the cases. Why? Because the interaction of 2 minds, 2 thought processes, each of which is different, produce inquiries which require response that leads to a greater understanding of what is the truth, how are you going to get there. There's one thing to know. Well, on Sunday I'm going back to Wilmington. Well, I know how to get there. I drive my rental car to Phoenix, take U.S. Airways to Charlotte, and another U.S. Airways to Wilmington. Well, you've known people in your life say, well, I'm going to go so-and-so. Well, how are you going to go? I don't know. Well, now, wait a minute. Wait a minute.
What about, you've mentioned it a couple times, the notion of your athlete and lawyer, like the relationship between being an athlete and being a lawyer, because you talk about teams and all kinds of things like that.
Critically important to me. I had a coach in high school who did more for me than any other person except probably my mother in my life. And when I was in high school, I stuttered so badly I couldn't carry on a conversation. I had absolutely no self-confidence. You wouldn't know that, would you?
Mm-mm. That's amazing.
He taught me how to get better. Taught me how to have a reasonable self-confidence without being pompous and egotistical, arrogant. The traits that nobody likes. And he taught me that worth is dependent upon the relationship of the person to the team effort. And to have a team effort, you've got to have a common goal, and you've got to have trust. If I didn't trust my teammates, I couldn't go out and give my all. There's so many things about competitive athletics. Football, I got knocked down hard a lot, okay? I got hit so hard one time by a linebacker from Glendale High School, a fellow named Bombo Arrow. I met his granddaughter some 6-8 months ago in Phoenix. I happened to be there. She asked me if I'd played football at West High, and I said yes. And she said that her grandfather had played football at Glendale. I said, well, what was his name? She said, Bombo Arrow. And this fellow hit me the hardest. I have never been hit so hard in my life. I went across the middle, caught a pass, and he smacked me, knocked me out. The ball went that way, I went that way. But I got up, you understand? I got up. I didn't lie down and quit. And it's that way in the practice of law. You're going to get adversity is going to hit you. You don't win everything. There are disappointments. There are huge negatives. You wonder, how in the world am I going to solve that problem? Why did God visit that difficulty upon me? But if you have been accustomed to the experience of getting knocked down and understanding that you've got to get up. It's you. You've got to get up. You need some help, but it's you who's got to get up. It can be of tremendous help. I mean, I don't know how a trial lawyer does it without an understanding that you're going to get some rocks. You can get knocked down. Period. Because nobody's perfect. And
when you get knocked down, how do you deal with it? I mean, do you just get up and shake it off, or what do you do?
Well, what I do is I get up, go back to my office, and analyze why I got knocked down. Why was I blindsided, or why did I go down an alley where defeat was inevitable? And I outline it. That's the way I remember it, so I try to avoid those things if I can.
We're running out of time, but I have 3 more questions, so I'll have to do this fast. You're very confident, and you know exactly what, I mean, at this stage where you are, you're strong and confident and know what you want and have a real strong sense of everything. I think starting out, sometimes people who are shyer, or, I mean, you had just talked about that you had stuttered and things, but maybe you could just talk about how, was that always the way when you first started, or did you learn along the way, and
Never always the way.
No.
The only thing immutable in life is there will be change. Now, when I first started practicing law, I knew I didn't know much, if anything. I mean, I just answered enough questions positively on the Arizona bar examination to be licensed. So, fortunately, I had a secretary who was a crackerjack. She could type 120 words a minute, take shorthand at 160 words a minute, and she was a very bright woman. And I said to her, I said, look, I've even forgotten her name at the moment. Take care of me, will you? I need your help. I mean, I'm a lawyer, but you know a whole lot more than I do. And help me. When you think I'm off on the wrong track, sit me down and say, hey. And she did that. And I've tried to use that throughout my practice of law, particularly the first 20 years, because it's a long voyage. And if you want to be there at the end, you got to have people who want you to be there at the end. This goes back and reflects on what I said earlier. You only succeed to the extent the people around you want you to.
Mm-hmm. Does that mean that you treat your staff, I mean, sometimes people are mean to their staff, or they don't respect their staff?
That's stupid. That's operating in an imperious, arrogant fashion never is productive. Particularly in today's environment. I mean, when I was your age, if somebody were imperious or arrogant to me and was a senior, I mean, yes sir, yes ma'am. That's just the way it was. But it's a different world today. I mean, I've got grandchildren who can secure more from computers than I ever thought about learning. Okay? So, the practice law is a people business. And the people around you, as I've said, can make or break you. And I have always found a tremendous resource in the knowledge of the people around me and their willingness to help me. And I've tried to cultivate that because I'm only one person. And that's not enough to get by. You know, I hear all along, I'm my own boss, and by golly, I'm the one responsible for my success and nobody else. And I don't owe anything University of Arizona College of Law. I don't owe anything University Athletic. I don't know. That's baloney. That's kind of arrogance that is almost pernicious.
That leads me to my second question, which is a question that Vicki likes me to ask. Your name is on a building, a new building here, and that's very pretty, and I'm in every day. And maybe we could talk about why your name's on a building, why you think it's important to give, and more in a bigger sense, what is giving to a school?
Well, I gave the university well, that's not true. I originally gave the university without any understanding that there was going to be a recognition. It's my obligation. It's my duty. Then the dean called me and said, got me on the phone with Jim Rogers and said, I want to give you fellows an opportunity to name this building, and if each of you will give X, then we'll do that. I said, fine, I'll do that. Because I thought the university needed the money for the building. See, I don't need any more recognition in my life. I got all I needed. I was playing basketball here and was a student body officer, SOFO, chain gang, Bobcat, bunch of things. I was been very, very fortunate. And I found that the more you give, the more you get back. And you don't have to tell people you've given. In fact, if you do, it takes a lot of it away. But they know. But that's not the important thing, that they know. The important thing is that, as I told somebody 10 years ago, if I gave $50,000 a year for the rest of my life, I would not have balanced the books with this university. It gave me so much.
And what do you do when you're starting out? What should you be giving back to? That's probably Vicki. What should you be giving a young?
Oh, I think that if you give $100 a year, and you keep in touch with a law school, you never know whether you're going to be fortunate and accumulate the kind of money that I've been able to accumulate, which enables me to give. And that's not because I'm smart. I got in a couple of business deals because a friend of mine who's a billionaire liked me and made a lot of money. Just ridden that horse. I told somebody the other day, I said, get a good horse and ride him, don't ever get off him. But there again goes back to the rule, always associate with honorable, successful people. I mean, I have found that my best clients, my best friends, are responsible, well-to-do people. They don't want any problems with the law. They don't expect me to do anything dishonest. They wouldn't ask me to do anything illegal any more than I'd ask them to do anything illegal, okay? It's when your friends ask you to do something that's illegal or immoral or unprofessional that this peer pressure causes you to compromise with propriety. And my mother told me there's a do-right rule. Adhere to the right, avoid the wrong. If there's a question in your mind about it, consult the Bible. It's very simple, son. It's very simple. Adhere to the right, avoid the wrong. If there's a question in your mind about it, consult the Bible. If you do that, you're going to be okay. Nobody does it always. But in associating with honorable and successful people, clients, partners, whatever. And when I've noted that a partner or business associate of mine and I are not on the same beam, so he doesn't think the same way I do about fairness and propriety, I need to do something else. Period. And I mean, I have 4 or 5 basic rules of success, and I never violate them anymore. Used to on occasion, and it always created problems. don't ever violate them anymore. And financial success is as fortuitous as anything I know. But I do know that if you're honorable and you work hard, the fortuity is more likely to come to rest at your doorstep than someone else's. So, I've accumulated more than I ever thought I would, but I owe this university more than that.
We're going to end on a question we ask everyone, which is happy moment in law. What an example of what you think of as a happy moment in your life in the law?
Well, there are two, probably. The first occurred after I'd been practicing law probably 3 or 4 years in North Carolina. I agreed to represent a young black boy for $500. He was charged with involuntary manslaughter in crossing the center line, actually a 3-lane road. He went out to pass the car, ran head on into another car. He's black, and the woman who got killed was white. And in 1964 in North Carolina, that was prescription for guilty. And I represented him in one of the big-time civil lawyers was private prosecution for the state. And of course, the fellow was convicted, and the case went to the Supreme Court, and I won in the Supreme Court. And the young black boy came in to see me, and I was very appreciative. It was a happy time. Another happy time was when we recovered $36 million from Conoco for a group of clients. That's a very financially happy time. But there's more to it than finances. Much more to it.
This has been great. Any other comment before we turn off?
Yeah.
Really nice. Thank you so much.
You're quite welcome.